null and void, and this is one of the cases we've stated before you, the case of McFoy versus United Africa Company, is captured in the following words. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have a court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. That is the fate the Form 36, the Form 34D, issued by the chairman of the commission in this matter, must suffer as well. Now, my learned friend, Mr. Mahat, has taken you through some numbers. And as I've demonstrated, and as was demonstrated earlier here by my colleagues for the first petitioner, when you have a process where the numbers are so adulterated, where the forms are so compromised, what numbers are we talking about? Numbers that have been verified or quote-unquote tallied in an unconstitutional matter. Our learned senior, I think Mr. Orengo, I think it was Otinde Amolo Senior Counsel, said that the numbers became a moving target. Now, in fact, they were behaving not more like a moving target, but like a group of naughty children in a nursery school running around the yard. It is impossible to get a hold of the number that was used either for the 50+1 or for the tallying or for the verification, which, as you have heard, was changed 3 times. Now, you asked, I think, of the petitioners, how did we get to this place? Like every slow train crash, a train crash in slow motion, those of us who lived through the repressive days that led to the Constitution of 2010 will tell you that it did not happen one day. My good friend Mr. Morogo has told you that the Gazette Notice by which the chairman appointed himself as the presidential returning officer. And we need to note, because the defense put here yesterday by the commission, was that he appointed himself on the basis of your judgment in 2017, where in passing, you said that there is a national returning officer. Now this year, he has upgraded. He upgraded himself to presidential returning officer. Now you've been told that Gazette Notice means nothing. And I think yesterday you were told we ought to be grateful to him because he had the good grace to publish in the Gazette his unconstitutional appointment. Now, whether you publish misconduct in the Kenya Gazette or you publish an offense does not imbue you with some sort of value or does not imbue that process with some good grace or quality if the Constitution does not permit that office to exist or does not permit him to conduct himself in the way he did. A Gazette Notice does not improve it. But perhaps more importantly, if it meant nothing, why publish it in the first place? If it meant nothing, why publish it at all if it meant nothing? But the point I wish to make is this. Complaints were raised. I think I've seen letters written by the party that nominated the first petitioner. There were newspaper articles complaining, Gazette notices, newspaper notices complaining that ballots had come without commissioners being told, but you'll get to hear that a bit more. There were complaints made by civil society. But as happened with Kenya, when we ended up in the position we ended up before the 2010 Constitution, we keep pushing these things away to the back of our mind. And people go to